Hello and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we update you with the recent important legal developments across the nation. Let's take a look at the headlines. Supreme Court upholds group of companies doctrine. Supreme Court seeks official data of beneficiaries of Section 6A of Citizenship Act on day 1 of examining the constitutional validity of the provision. Delhi High Court directs state government to raise EWS quota threshold to ₹5 lakhs annually, orders stringent verification. Allahabad High Court grants relief to Akhilesh Yadav in Model Code of Conduct and COVID norms violation case. Karnataka High Court suspends live streaming and video conferencing amidst hackers playing obscene videos. Over 100 websites blocked by government for involvement in investment and job frauds. Now the headlines in detail. Today, in a landmark ruling, the Supreme Court has upheld the group of companies doctrine, which provides that an arbitration agreement entered by a company within a group of companies may bind the non-signatories. The top court clarified that it is not necessary for a person or an entity to be a signatory to an arbitration agreement in order to be bound by it, if such parties demonstrate a mutual intention to be bound by the agreement. The Apex Court noted that the group of companies doctrine must be retained in the Indian arbitration jurisprudence, considering its utility in determining the intention of the parties in context of complex transactions involving multiple parties and multiple agreements. The verdict was delivered by a constitutional bench comprising the Chief Justice of India D.Y. Chandrachud, along with Justice Hrishikesh Roy, Justice P.S. Narasimha, Justice J.B. Pardiwala and Justice Manoj Mishra. The CJI, while pronouncing the decision, said that the signature of party in agreement is the most profound expression of consent to submit to jurisdiction. However, the corollary that persons who have not signed are not part of the agreement may not always be correct. The Supreme Court yesterday commenced the hearing of batch of petitions seeking scrutiny of the constitutional validity of Section 6A of the Citizenship Act of 1955. A 5-judge constitution bench led by the CJI D.Y. Chandrachud, alongside Justice A.S. Bopanna, Justice M.M. Sundaresh, Justice J.B. Pardiwala and Justice Manoj Mishra, directed the Solicitor General of India, Tushar Mehta, to furnish official data pertaining to the number of people benefited from the provisions outlined under Section 6A of the Citizenship Act. Senior Advocate Shyam Devan argued for the petitioners and contended that the influx and the special provisions have tangible ramifications on the socio-cultural, economic and other rights of the indigenous people in the region. The top court expressed that there was no material before it indicating that the conferment of Indian citizenship upon Bangladeshi immigrants between 1966 to 1971 has substantially altered the demographic and cultural landscape of the border state. The CJI acknowledged the persistent issues of cross-border infiltration in Assam, drawing attention to the humanitarian aspect of 1971 war between India and Pakistan, which led to the influx of immigrants. To give you an overview of the issue, Section 6A was inserted in the Citizenship Act as a result of the Assam Accord in 1985. The accord was signed between the centre and leaders of the Assam movement and aimed to deport illegal immigrants from specified territories, including Bangladesh. Section 6A requires that any person arriving to Assam between January 1, 1966 to March 25, 1971 should register under Section 18 of the Act for acquisition of Indian citizenship. The petition challenges the said provision for being arbitrary, discriminatory and unconstitutional for providing different dates for regularizing illegal migrants in Assam. In a significant development, the Delhi High Court has issued a directive to increase the income threshold for admission to private schools under the economically weaker section quota from the current 1 lakh to ₹5 lakhs annually. The court also emphasized on the need for standard operating procedure for income verification and elimination of the present system of self-declaration of income by parents. The court ruling comes during the proceedings of a case involving a parent securing his son's admission to Sanskriti school under the EWS category through fraudulent means. While dismissing the petition challenging the cancellation of admission, Justice Purushendra Kumar Kaurav granted permission to the child to continue with his education at the school as a general category student, emphasizing that the child should not suffer for the misdeeds of his father. The court further imposed a fine of rupees 10 lakhs on the father for his act of obtaining admission using illegal means and directed the father to deposit the same within a period of 6 months. The court also said that failure to comply with the monetary penalty, the admission of his son will be deemed cancelled. The Allahabad High Court extended a reprieve to former Chief Minister of Uttar Pradesh and Samajwadi Party Chief Akhilesh Yadav by putting on hold the proceedings initiated by a local court. These proceedings were in connection to alleged violations of the Model Code of Conduct and COVID-19 norms during the assembly polls in Uttar Pradesh in February 2022. The case was registered against Akhilesh Yadav, Rashtriya Lok Dal Chief Jayant Chaudhary and others at the Dadri police station, which prompted the court proceedings at Gautam Budh Nagar District Court. However, Justice Rajbir Singh of the Allahabad High Court, while hearing a petition filed by Yadav, challenging the summons issued by the magistrate of the district court, temporarily halted the proceedings of the district court. The High Court also directed the counsel for the state to file a reply in the matter, which is scheduled for hearing on January 21, 2024 now. In a shocking turn of events, the Karnataka High Court was compelled to suspend its live streaming and video conferencing services owing to a cybersecurity breach. Chief Justice Prasanna B. Varale expressed deep concern over the misuse of technology after hackers infiltrated the system of the High Court and played obscene and indecent videos on its feed. Chief Justice said that the unfortunate and unprecedented situation necessitated a temporary halt to the online services of the High Court. CJ Varale further said, Karnataka High Court was always in favor of technology being used for better services for the public at large. Unfortunately, technology is being misused. A complaint with regards to the incident has been filed with the Cybercrime Cell and the Central Division has launched an investigation in the matter. In a concerted effort to curb cybercrimes in India, the Ministry of Home Affairs has identified and recommended the blocking of over 100 websites, facilitating organized illegal investments and task-based part-time job frauds. As part of the initiative to safeguard citizens from threats posed by cybercrimes, the I4C, short for Indian Cybercrime Coordination Center, has been launched. A vertical of I4C identified the unlawful websites, and subsequently the Ministry of Electronics and Information Technology blocked the websites, conducting illegal investment-related economic crimes and manipulation of victims to lure them into making investments in the name of task-based part-time jobs. In addition, to protect citizens from falling prey to such scams, the Ministry of Home Affairs also issued precautionary measures. These include exercising due diligence before investing in high-commission online schemes, refraining from financial transactions with strangers on messaging platforms, and verifying the legitimacy of UPI transactions. That was all on today's legal news. Thank you and keep watching Verdictum and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.